Hi, everyone. It's Monday, June 23rd, and I thought I'd put up a quick, modest review of Chapter 8 on consideration. Very important element within any contract. And again, going back to Chapter 5, remember the first element is the offer and acceptance or the meeting of the mind, the heart and soul of contracts. The second element is capacity and consideration. Fairly straightforward concepts, I think. We want people to have the mental wherewithal and age in order to be forced to comply with a contract or suffer for ramifications, so be sued for damages. And the next element is consideration. It has to be a bargain for exchange. And I don't really like the term consideration. I think it throws people off because usually when I hear the word consideration, I think that's being thoughtful towards another person or being kind and respectful. That's not what we mean here. Consideration means some kind of legal exchange. If there's not a legal exchange, there's not a contract. There may be rights and duties between the parties that might exist, and there is an exception in the book that we'll go over called promissory estoppel, hopefully fairly soon. First, we have to talk about this exchange of legal detriment or legal obligation. Oftentimes it revolves around sales. I go and buy this simple little watch at Walmart and I pay them $50. That's the exchange. I get the watch, they get the $50. That's the consideration. It's that simple. It gets a little complex when it comes to issues of the disparity sometimes in the value of consideration. And that's often a test question, and I think I have it posted or going to pop up on the discussion board fairly soon. I think I'll have these springing prompts for you guys to talk about. I always find it fascinating that sometimes people are deeply troubled by gross disparities in consideration. What if this was a Rolex and we know objectively a used Rolex in good condition, good working order, and a true Rolex manufactured by the real Rolex company? Say we know objectively after appraisals and everything else, this could get on the market $5,000. It's not a Timex, but just for purposes of today. And I sell it to you for $10. Is that a valid contract? Well, there's an offer. I offer to sell it to you for $10. You accept. I give you the watch. That's the consideration. You give me the $10. That is your consideration. It looks like we met the first two elements. Well, one thing we still have to consider is capacity and competency. Well, let's assume we're both over the age of 18. We're not currently serving time in a state prison. Neither of us have been adjudicated mentally incompetent, but we might be. That's one of the things that we care about, or at least give thought to. Why do we care a little bit about gross disparities in the exchange of values between the two parties? Because it may be evidence of lacking of competency. So if later I came in and said I was suffering from some very severe mental limitations on the date and time that contract was entered into, my proof might be a bunch of doctors coming in and testifying, and maybe family and friends testifying that I suffer from a certain limitation, as well as doctors. And what else would be evidence of it? The gross disparity between the consideration being exchanged. But as a general rule, do we care that people take advantage of one another in business? No, we don't. I shouldn't say we don't, but the law doesn't. So if you go out there and find bargains, that's, I guess, part of what business is about. It's buying low and selling high, right? Real simple sense if you're going to be a transactional business person. So we don't care generally about gross disparities in value, but sometimes it helps to use that evidence for things like lack of mental capacity or competency. And in a later chapter, we're going to talk about duress and undue influence. And it would be perhaps evidence to bolster your argument that maybe that contract was entered into because of that. But again, consideration, just what's mutually exchanged between the parties. There has to be some legal detriment flowing back and forth, or it's not a contract, it's something else. It can be for money for services. It can be services for services. You'll wash the windows in my house and I'll mow your lawn. That's what's going to be exchanged. That's a valid contract. It's not any kind of physical property or money being exchanged, but it is a legal detriment. We have to perform services for one another. What's interesting and fascinates a lot of people can also be refraining from something you have a right to do. So I always bring up this one. I have this sort of fantasy, or I shouldn't call it fantasy, it's actually a dream, to live near the ocean. And I know I'll probably never afford anything right on the water, but maybe I'll get fairly close, maybe a few blocks away. Maybe I'll have an ocean view from the upper level of my home. What if my neighbor, who has a legal right to do it, decides they're going to put a second story or a third story in our house and it's going to block my view of the bay? Could I pay them money to refrain from building that third story on their home that they have a legal right to do, yes, that would be a valid contract. If I pay them $10,000 to not go forward with their plans to build a third story on their home, that would be a valid contract. What are they giving me? They're giving up a legal right, a legal right to have done just what they intended to do, to go and build a third story in their home, and I'm giving them $10,000. But what do you have to refrain from? You have to refrain from doing something you had a legal right to do in the first place. I always bring up the other example. What if somebody was picking on me at the mount illegally? They're pushing me and shoving me around, and someone says, "Hey, if you give me your lunch money every lunch money, sounds like a little kid, but that you give me $5 a day, I won't slap you in the back of the head every day." Well, did they have a right to slap me in the back of the head every day in the first place? No, so that would not be valid consideration. So at the end of the year, I say, "Don't worry, I'll pay you at the end of the year. It's going to build up." And at the end of the year, they come looking for their money, and I said, "I'm not paying you because that's not a binding contract. Because although my consideration was valid, your consideration, refraining from committing an assault and battery on me on a daily basis, is not refraining from something you already had a right to do." Those are obvious ones. The ones that are a little bit more tricky, I think, are kind of fun because it makes you think a little deeper about this concept of consideration. One I'll give you is, okay, say I'm working at the Mount and I usually have a day class at 8 o'clock in the morning, but because I have to get my kid on the bus and take care of other issues before I get off to work, I'm driving over an hour. I'm late every day. And let's say the Mount likes me. They think I'm doing a really good job, but it's really irritating them that I'm showing up late for my 8 o'clock class pretty much every day. Students are saying, "Hey, Corman's great, but man, 10 minutes late every day, I'm paying for this." So somebody from the college approaches me, talked to me about it. I'm like, "Geez, I just wish I had more incentive to be here on time." And what if they said, "At the end of the year, Jim, if you show up at your 8 o'clock class on time for the rest of the semester and the spring semester, we're going to give you $1,000 bonus." I said, "Great. Let's just only sign it." A lot of people want to see this stuff in writing. I know students are still hung up on this concept that you have to have things in writing. You don't. It makes things a lot easier to prove. But generally speaking, many of the contracts do not have to be in writing. So let's assume everyone agrees it's on video, it's written down, and all that stuff. They're going to give me $1,000 to show up on time. At the end of the semester, I go to collect it and say, "Hey, Jim, we're having really tough budgetary times. We're not going to pay it." So I say, "Hey, we had a contract. I'm going to sue you." So I take them to small claims. Would the judge at the small claims force the college to pay me that additional $1,000 per semester for showing up on time? No, because my consideration was illusory. It wasn't real at all. I already had a legal obligation or contractual obligation to show up at 8 o'clock. I'm not putting anything new into the bargain for exchange. They're giving me something new. They're giving me $1,000, but I'm not adding anything new that I didn't already have to do. I think you get it. The same with illegality. If I'm paying someone to stop doing illegal behavior, and then at the end of the time period, they say, "Hey, I didn't do those crimes. Pay me the money," I wouldn't have to pay because they already have an obligation not to commit crimes. I think that makes common sense. But I think it's a kind of a turning point when it comes to contracts for like construction. This happened in my own practice. A good friend of mine, he was actually working right off the town common in Sturbridge, and I would drive by because my office was in the next town down at the time. And I would drive by and I see his truck with his insignia on the side, and I'd stop over with coffee and talk to him. He was doing some very kind of interesting work. He was building a deck out of, I think, cypress, some quasi exotic wood, and it was kind of really fancy. He was kind of bragging to me. He says, "Hey, the homeowner's so happy with this. She's throwing me a $2,500 bonus on." It was a big job. It wasn't just the deck. There was a lot of other work. She's really happy how it's coming out. She's giving me an extra $2,500. Great. A month goes by. He stops down my office and he goes, "Hey, Jim, I got something to show you." So he shows me his contract. He shows me the check he's got from that client, and I'm bewildered. I'm like, "What's the matter?" He goes, "Look, it's X number of dollars. That's what the contract. Remember, I told you she was going to give me $2,500 extra because she was so happy with the job." And I said, "Oh, she didn't give you that, huh?" And he goes, "No." And I said, "Oh, that's awful." He goes, "Well, what should I do?" I said, "Well, call her up and say, 'Hey, don't you remember I promised you $2,500? Maybe she just forgot." And he goes, "Yeah, but I mean, what happens," he says, "if she refuses?" And I said, "I'm sorry, nothing happens." Why? She promised to give you $2,500. What did you give her? Nothing. Nothing new. You were already obliged to do the job that you were doing in a workmanlike fashion, and you were doing that. You had nothing new to bring to the table. And I told him in the future, if somebody says, "I'm really happy how this is coming out. I'm going to give you another $500, or I think this is great. I'm giving you another $1,000." You turn around right then and there and hopefully put it in writing because you want proof. You say, "In light of the promise for you giving me an extra $1,000, I'm going to put an extra coat of polyurethane down, or I'm going to add this feature." It doesn't even have to be equal. Don't Why would you want to do $1,000 worth of work in exchange for $1,000 if you can get away with doing something that's like at $10 of value? So just say something. I'm going to finish a day earlier. I didn't have to, but I'm going to finish a day earlier in light of your exchange for giving me some more money. That would be a binding form of consideration. Totally valid. So most of the concepts are straightforward, but sometimes the concept of, that's called past consideration, terrible term because it's not consideration at all, but it happens all the time. I work for the Mountain for, say, 30 years, and I go to retire, and they say, Jim, you were really great at the college. You really brought about a lot to the table. As a result of that, we're going to give you a COVID cruise on the Princess of the Seas and the Caribbean. I couldn't think of a worst gift ever. But anyways, they want to give me this gift for a cruise, and I'm all happy about it. And a couple of weeks go by, I don't get anything in the mail. No one's talking to me. And I call the college, hey, where's my Norwegian cruise to the Caribbean? And they say, well, we come up with a budget shortage. We don't have it. I said, well, you promised it to me. What did I give them in exchange for the cruise? Did I do any more work? Did I teach an extra class? Did I clean the windows? I did nothing new. They were rewarding me for past behaviors that I already had performed. It wasn't bargained for. And that comes up a fair amount of times in business. But I hope you get that sense of what's going on there. Again, adequacy of consideration. We usually don't care about the gross disparity or the quality that's being exchanged between the parties. People, I hate to say it, are free to really drive a hard bargain and make profits. But it could be proof of lack of mental competency or potentially duress or fraud, which we'll get into later chapters. Part payment's an interesting concept. What if you owed me $500 and it was payable today, right now at 1:30 in the afternoon, and you come in and say, I don't have the $500, Jim. Will you accept $400? It's okay, give me the $400. Are you relieved of the other obligation to pay the final $100, or could I sue you for the balance? Most people say, well, no, you've accepted the $400. Yeah, but lowering the amount to $400 was in exchange for what? You gave me nothing new. So believe it or not, I can actually sue you for that remainder, even though I said okay, because you already owed me $500. What contractually are you changing from my position, from your position, for the reduction of $100? Nothing. So a past due debt that the creditor accepts a lower amount isn't enforceable unless it meets one of the 5 exceptions in your book. I think it's on page 79. It is on my book. Hopefully it's on the same page in your book. One is if in the amount's dispute. I don't really believe I owe you $700. There was a contention about what was supposed to be performed. I really think I owe you $500, and that's what I'm going to pay. Well, now the amount's in dispute. So therefore, the consideration is both of us waiving our potential dispute over it. That is a form of consideration, and that's commonly what the parties do. I always urge you to write it down, that this amount is in dispute, but we're accepting this as a resolution of our contested claims. So if the amount's in dispute, you can accept the lower amount, and it will be a binding resolution to the outstanding debt owed. The other one is something called a composition of creditors. Say I owe 15 different people different amounts of money, and I'm fearful I'm going to have to go through bankruptcy, but I contact them all and I'll say, instead of you guys getting nothing, I'll offer everybody 50 cents on the dollar. We'll all get an equitable share of what I have for resources. Will you accept that? The law says this concept called the composition of creditors is a form of consideration flowing back and forth between the multiple creditors. It's like a legal fiction. We're going to allow that to be enforceable against the creditor for the debtor's benefit, even though the debtor's giving up nothing new to the other side. Arguably, I always thought they are giving up something, giving up the right to file for bankruptcy. But you need 2 or more creditors to agree to reduce the amount of money owed between them. And there's this legal sort of, I guess, exception or legal fiction that allows that to be equal to a form of consideration, so composition of creditors. The other one is if the debt is evidenced by a promissory note. You have a $1,500 IOU from me that is payable today, June 23rd at 2 p.m., and you possess that. You're hoping to get paid today, that $2,500. And I come in and say, I can only come up with $2,200. We accept it. You say yes. If you write on that promissory note, paid in full, and return it to me, the law says that will satisfy the resolution of that claim, even though it doesn't have consideration for the lesser amount. It's a form of consideration, exchanging the promissory note saying paid in full. The next one, a gift. You can say, but you better write it down. You can say, okay, I owe you $2,500. We accept $2,000 today. I'm really broke. You've known me for a long time. I feel terrible, but I can't pay you the other $2,500. I just can't do it. And the other side knows they have a right to sue you. They should know they have a right to sue you, but they can gift it. They can say basically, I'm going to give up my right to seek that other $500 as a form of gift. You should always write it down, because if you didn't, they could just sue you and say, I never gave up the right to pursue that other $500. They're, out to lunch. I don't know why they said that. So gifting, you're always free to gift up an obligation. You're always free to walk away from a contractual obligation if you're the one being shortchanged, if you will. People don't have to enforce their rights. That should be a common sense principle understood in the law. In the business, the whole thing of contract law is freedom of contract. So you're free to do many things within the realm of law, including giving up most rights, not all rights. Some rights you, believe it or not, can't legally give up. The last one is not going to come up too much. You owe me $100,000. So instead of you paying me that, you say, I'll pay you $90,000, but I'll give you a mortgage on my home. So in case I default on that when payment comes due, you'll have a security interest. Well, that is a form of consideration. I'm getting some new legal exchange here. I'm getting new rights, and you're giving up rights. So I don't always like including in this section of a partial payment of a past due debt, how it actually works. But that's one. I don't test a lot on that one, but it is fascinating when sometimes people think like, hey, I owe somebody $30,000. Can I pay them $25,000 if they accept? Sure, but they can sue you for that other $5,000, even though they said they accept it, unless you do those things I said. Put in writing that they've waived the other $5,000 as a gift to you, or that the understanding was that the amount of $30,000 was in dispute, and this is a resolution of a disputed amount of money in a written form, or the amount of money that was owed is evidenced by a note, an IOU, a promissory note, and they sign it paid in full, and they give you that note as evidence that they accepted the lesser amount. Other than that, you could potentially be sued for the balance. This is this composition of creditors, or that secured transaction I talked about, putting a mortgage on a home, or a secured lien on a car, or something like that. What is insufficient or invalid consideration? Already talked about a couple of them. Performing what you already had an obligation to perform. Jim, you're supposed to show up at the mount at 8 o'clock every day. They promised to give me more money to do what I'm already supposed to do. That's invalid. I already had an obligation to do it. You can't enforce that. I actually knew somebody when I was in college. I was very young. The parents would actually pay them a fairly wealthy, I thought very healthy allowance each and every month if they tested clean for marijuana. The parents were very concerned that this young lady was smoking marijuana. Parents didn't like it. They were very conservative, and they would actually pay her amount of money each month. And she had to take urine screens or some kind of drug test. I don't know if it was hair follicle, whatever it was. And if she passed, she got this healthy allowance, very healthy. I never experienced that growing up with wealthy parents, but there are people out there like that. And I always thought later on, because that always stuck in my mind, how she had this ability to have a lucrative allowance from her parents based upon testing clean for marijuana. And I thought back then, not anymore, because she was an adult, she was over the age of 21. Parents trying to keep control, I guess. But what's interesting to me is that's not an enforceable contract then, because back then, could you legally smoke marijuana at the age of 21? Even back then, they didn't have the medical card in Massachusetts. This is a long time ago. And so the contract, so say she will say, we're not going to pay a month, we're going to pay at the end of the year. You do 12 tests that are clean over the 12-month period, we're going to give you X number of dollars. And then let's assume she does. She tests clean, and she could not enforce that contract back in the 1990s. Why? Because back in the 1990s, it was already a legal obligation not to smoke marijuana. Totally unenforceable contract. There's no valid consideration flowing back and forth. Doing or refraining from doing what you have a legal obligation to do or not do can't be valid consideration. That's past performance. I talked about past performance. You've already done something. I always think at a time, I helped a friend of mine. He had a small cottage and a fire in it, and we were kids, but his father's camp or his parents' camp. And we went, and the parents said, hey, how would you like the guys kind of go out and try to remove some of the interior and burnt furniture that was in there? It was a pretty bad fire. And he bought a big, I don't even know what 30-yard dumpster means, but one of these huge dumpsters that goes on the back of a tractor trailer. And we did. We stayed out there 4 days. We stayed out like in tents, and we showered at this campground down the road. We worked really, really hard. The guy was so happy that I remember the guy was actually sobbing because camp seemed like it was salvageable after it was cleaned out. And we were kids. We were like, I don't know, very young, 15, 16, something like that. And I always remember him saying, and this is a long time ago, so you guys don't probably appreciate the value of the money, but he said, hey, you guys, I was so pleased. There's 5 of us. He goes, I'm giving each one of you $100. He goes, I'll pay you guys next week or the week after. I'm really pretty. We saw that. It was a beautiful moment. There were a couple of weeks went by, and I never saw the $100, and I was with the other gang of kids that we grew up with, and we asked our buddy, said, hey, I thought your dad was going to give us each $100. And he approached his dad, and his dad had actually just gotten laid off at that time, and he says, he's not going to be able to pay. Well, we're obviously not going to, I like to think we're decent human beings, so we weren't going to pursue it or anything like that. We were actually glad to help. But what if we wanted to? Could we have sued and sought $100 each? Because that's what was promised for. We gave them all this work. He was going to give us each $100. But it wasn't bargained for. We weren't doing the work initially based upon the promise of us getting $100. We did the work as a gratuitous thing that friends do, and then afterwards he promised to give us $100 for what we already had performed. That's not a bargain for exchange. It's not valid consideration, not an enforceable contract. I think that's kind of pretty interesting. The book does a nice job talking about the differences, like, illegal, and it's not always immoral for something to be illegal, but if you don't have a right to do it, it's not valid consideration. So if I had a friend of mine who has a bad marriage and I tell her, I'll give you $10,000 to divorce your husband, and she turns around and divorces her husband, even though it's a good idea because her husband's a real jerk, that's not valid consideration because it's considered illegal to induce somebody contractually to end a marriage. I know it's really esoteric and narrow, but things like that surprise people sometimes. It's just invalid consideration. You don't have a right to do it. It's against public policy. Pretty straightforward. Now, the big one probably should have, I should mention voluntary subscriptions. That's basically, and I hate the term subscription. I think you're buying a magazine, right? What I'm talking about here, voluntary subscriptions, is donating to a charitable organization. Usually, I think to have the law clear, it usually has to be one of those things that are recognized under the IRS. I think it's a 503C or 501C. I can't remember the numbers. I'm not a tax attorney. And so you donate some money to PBS or some other charitable. I'm thinking about Jerry Lewis. Jerry Lewis is no longer on there. He's dead anyways. But back in my day, Labor Day weekend was always dominated by the Jerry Lewis telethon, the MDA telethon, muscular dystrophy. If you call in and promise to pay $100 towards that beneficial organization, that's a fully enforceable promise, even though they're not giving you anything back in exchange. Some people say, well, they're giving you that show on that entertainment show. No, that's gratuitous. But I think you get my picture. If you promise to donate to the MSPCA, you see these commercials with these dogs that look like puppies that look like they're crying in cages and they're freezing and shivering, and they have that, I think it's Sarah McLachlan's her name, that tearjerker song in the background, and I'm like, it's like commercial lasts for like 3 minutes, and I'm like bawling in my living room, and I'm about to write out a freaking check for my entire ballads. If I didn't write out the check, but I called them and I promised to make that donation, believe it or not, that would be enforceable against me. It's called a voluntary subscription. And the law created that exception because we don't want people to go around making promises to charitable groups, just walking away from the obligation. Otherwise, people would do that probably more often than not. And that sounds terrible, but there's some truth to it. And organizations, especially big businesses that make charitable donations, usually just don't cut the check. They make the promise and they have a lot of pomp and circumstance about their charitable donation, and the check comes later. And you want to be able to enforce that. These charitable organizations aren't going to be able to survive, and most charities benefit society as a whole. So society, through law, created this exception to voluntary subscription. And I know you guys don't want me to go on forever, but I'm a big fan, or was. I don't watch it as much anymore. But it was a show called The Simpsons, and Homer Simpson's watching something called British Men Behaving Badly. I always remember the title. It was on PBS, and he loves his television, and he's drinking his beer, and he's watching this show of British people hitting each other over the head with frying pans or something he thinks is hilarious. And all of a sudden, Betty White comes on. It's a cartoon, but the character Betty White is in this cartoon form, and she goes, we have to interrupt this PBS showing of British men behaving badly so we can raise $10,000. And Homer's very upset because he has something else to do, who knows what. And so he calls in anonymously and makes a $10,000 pledge. And of course, he reneges on it because he doesn't have $10,000. And what was funny about that is they could have just sued him for that, and it would have been fully enforceable against him as a voluntary subscription. But to be funny, they had all the monster characters from Sesame Street, Big Bird, Ernie, Elmo, all the other characters come over with baseball bats and chains and things like that to enforce Homer's pledge. And Homer had to leave and became a missionary on a small island in the South Pacific to teach, I guess, religion. I have a whole other story. Anyways, but voluntary subscriptions are fully enforceable even though there's no consideration. Debts of record, that's just simply a judgment. So if I sued you for negligence, there's no consideration flowing back and forth, but I win the negligence lawsuit. The court says you have to pay me $10,000 in damages. There's no consideration there, but you have to pay it because it's a debt of record. It's a court order. Obviously, there's no consideration flowing back and forth there, so it's fully payable. Not everything in life relates to contracts. Sometimes there's just obligations that the court has, court or some legal authority. It's not always court, but some legal authority says you owe money for taxes or something, whatever it is. Those kinds of things are enforceable without any kind of exchange of consideration. Now the big one should have a chapter in itself, and I'm going to spend a little time on it because it's one of my favorite topics. It's called promissory estoppel. This is, again, it's like fancy words. Why do they call it promissory estoppel? Estoppel means you're basically precluded. You're not allowed to raise a defense of there is no contract. So that's what the estoppel part means. Promissory is almost self-descriptive. I like it. Basically, if someone makes you a promise, so there's 4 elements in your book. It's pretty well outlined, but it's an interesting concept because it does come up as a wild card sometimes. I can't enforce a contract. There's no valid contract, but I need to enforce something against the other party. Something unfair has really happened here, and the law should recognize it. It's either unjust enrichment we talked about before, you're getting a benefit from another party and you never objected and you really enjoyed that benefit. You should pay the reasonable value even though there was never an agreement flowing back and forth. That's unjust enrichment. This is very related to it. It's another equitable principle. A promise is made. The promisor, the one making the promise, reasonably expects to induce conduct by the other party. The promisee, the recipient of the promise, does in fact act. And this is the biggest element. Justice really requires enforcement of that promise, or there's really going to be harm to the other party. I'll give you the not perfect example, but the example I always like to tell. I kind of have a dream to live on Martha's Vineyard someday, and I don't know how I can do it. It's probably never going to happen, but aim high, and if you fall short, you might end up pretty close. So that's sort of my motivational mantra of the day. So I was just thinking, well, I go to these conferences sometimes, and there's other colleges and other faculty and deans and things, and you meet different people, and I put on a nice dog and pony show, and I get along with people. I always have this recurring fantasy that I meet somebody from Cape Cod Community College, and they say, oh, Jim, we got an opening for a political science, history, legal studies professor or something like that at Cape Cod. You'd fit in great. He goes, you're thinking about relocating? I goes, well, yeah, as a matter of fact, I am. And there's a little conversation. I don't promise anything. Because if I promise something, they promise something. That's a contract. They don't have a problem. It's easy. But what about this? I'm just sitting there, like, well, I'm thinking about it. I don't know. And they said, Jim, tell you what, I guarantee you, I'll get you that job. You're going to start fall 2022. We're waiting for this other person to retire. You're going to backfill that position. It's going to be great. You're going to transfer over your tenure. You're already in the community college system. We're going to give you the same pay. We can't give you an increase because there's collective bargaining issues, and you basically just slide into the position with all the rights and benefits you currently have now. It's going to be great. And they tell you this. Not only that are we promising you this job, but we know that as a result of it, go buy that house on Martha's Vineyard. Go, have your mother pass away so you can inherit some money. Scrape up whatever money you can from your kids and your family. Do what you can, but get that chicken coop somewhere in the middle of Martha's Vineyard, and you can live your dream. Do it. Sell the house you're currently in right now. Change it, and give the Mount a notice. Quit the Mount. Tell the Mount effective, the spring semester you're done. After spring semester 2021, you're done, and let them know you're gone. Give up your house, sell your car because you're going to be riding a bicycle and just taking the ferry from now on. Do all those things, and they're serious though. They're seriously intended. And what if I actually, because of that promise, do all those things? I give them out the notice I'm quitting. I sell my house. I sell many of my personal belongings so I can muster up enough money for a tiny little place somewhere in the middle of the island probably. And I give up my car, and I get a bicycle, or I have a bicycle. I just take the bicycle and put those bags on the side so I can commute back and forth to the community college right from the ferry. I'm all excited, and all of a sudden the fall comes around, and I start calling them a few weeks before. I said, I didn't get my schedule yet. What's happening? And they said, we're not going to give you that. I said, yeah, but you promised me, and you told me all those things related to the promise to make me take detrimental reliance. If you ever go to law school, take other law classes like this, and expand. That's often the term they give synonymously with promissory estoppel is detrimental reliance. I relied to my detriment on a serious promise that you made me, and it was reasonably expected that I do it. This comes up a lot in employment. It's probably more in employment than anywhere else, but it can come up in sales of goods too. Same thing like a car. You go look at a car and you're saying, geez, I'm not sure. And the person says, hey, don't worry. I'm going to sell you this car for $2,000. I just need it for another month. You got it. Okay, I'll think about it. Don't worry, you don't have to think about it. I'm going to hold it for you for a month for $2,000. You don't buy those other cars, those other opportunities that come up, and sell the car you have. Don't even get it fixed. Give it to your friend that you wanted to do because they like that car and they want to fix it up. Do all these things, and I'll have this car available for you next month. And I don't know. He goes, well, don't worry. That's what I'm going to do. It's going to be available for you. And then you go get it next month, and they say, no, I decided to hold on to it. Can you see why maybe that should be enforceable against that person if, in fact, you gave up other opportunities to buy a like kind of car, and you gave up those opportunities, it's going to cost you more to get something else. You gave up the current car you have based upon that promise, and they knew you were likely to do it, and in fact, you did. That's why sometimes when you go for job interview, especially if you get called back and you do a second interview, sometimes you'll leave. They make you sign a form and they give you a copy of it saying that as a result of today's meeting, no promise of employment was given to you because they don't want a lawsuit based upon an argument that they made some kind of overt promise to you that you had employment. And it's a real concern. So a lot of the bigger organizations that are out there, corporations, have this culture where they're trying to avoid lawsuits over promissory estoppel. But it's the great wild card. Your promise to me made me take action to my detriment, even though I didn't give you anything in exchange. I didn't promise I was going to do anything. I wasn't committed in any way, shape, or form on my end. But your promise was likely to induce me to behave in some way to my detriment. And if your promise is not enforced, a great harm will be caused as a result of that. Of course, I have to prove all these things were said. And that's the real rub sometimes. And a lot of students in the live class say, well, how do you prove it? They're just deny saying it. Well, that is a real issue. But let's assume we all admit that these things were done. Promissory estoppel can really hook another party. So be careful what you promise other people. You may be obliged to comply with your promise if it's inducing behavior on the other side and it's expected to do so. Injustice requires. 4 elements. The last, it literally has a sentence or two. It has 2 sentences. That's it. Modification of sale contract. Generally speaking, if I have a contract with you and you're going to redo my kitchen, gut it, do the whole thing, and it's $25,000. And then you as a contractor come back to me and say, Jim, this has been a real pain in the butt job. I need another $3,000. And I say, okay. You finish the job and you ask for, I already forgot what the first figure was, but you asked for the additional $3,000 that I said okay to. Do I have to pay that? No, because what did you give me in addition to the original contract? Nothing. I'm giving you another $3,000. What are you giving me? Nothing. You're just doing what you're already supposed to have done. Past consideration, no new legal obligation on your part. So in order to change the terms of a contract, both parties have to receive something. It doesn't have to be equal. It doesn't have to be significant, but both parties have to change your position. So if you hire me as your lawyer and I'm going to do your divorce for you, and I don't know, I charge you, let's say some attorneys do flat rates. I'm going to charge you $5,000. There's no kids involved, so it shouldn't be such a nightmare. I'm going to charge you $5,000 flat rate. Then all of a sudden as things going, I'm saying, geez, this is really becoming complex. I really need some more money. And you say, okay, I'll give you another $2,000. Like, yeah, I asked for another $2,000. You say yes. That would not be enforceable against you. You wouldn't have to, because I already agreed to do your entire divorce from beginning to end. And all of a sudden I'm asking for more money and I'm not giving you anything new. And you're giving me $2,000 more. There should be some new consideration. So what if I said, I really need some more money, and as a result, I'm going to ask you for another $2,000, and I'll also write you a simple will, the healthcare proxy, and durable power of attorney for your family. Now I've added something new. Now that we're binding. There's a major exception to law, and it's on page, and you got to know this one. I will ask a test question on it. Page 83, definitely in the final. It's called modification of sales contracts. And what's difficult about this portion of the book, we haven't gone over sales yet. All sales are things for movable, identifiable goods. Cars, phones, books, clothing, eyeglasses, the lamp behind me, the chair I'm sitting in, the clothes I'm wearing. Those are all goods. Whenever we have a contract over goods, it's a sales contract. That's different than a contract for intellectual property like patent and software. It's also different than real estate contracts because when you're talking, it's a whole different realm of law, and we'll go over it too a little bit. So no panic on that. But when you're talking about sales contracts and we want to modify it, I'm buying $10,000 or 10,000 ball bearings from your company for $300. And you call me up and say, Jim, the price of steel has really gone up. I'm going to need $350. Well, generally speaking, we already got an agreement, $300 for 10,000 ball bearings. If I agree, I wouldn't have, and you send me the ball bearings, I really wouldn't have to give the other $50 because you've gotten something new in consideration, a different amount of money, got an additional $50. What did I get? I still get the same thing. I get the 10,000 ball bearings that I already was obligated to get. So the law recognizes when it comes to the sale of goods, movable, identifiable objects, there should be more flexibility in the law. We should be able to modify it as long as both parties voluntarily do so, even if there is no consideration flowing back and forth. It's a major, gigantic exception. Everything I just talked about just got thrown out the window, didn't it? But it's only within that realm of goods. So if, I don't know, I'm Home Depot and I'm buying a bunch of snow blowers come the fall to be sold at my Home Depot chains throughout the United States, I don't know what I'm buying. I'm buying a $10 million worth of Turo snow blowers. And they're going to give me for $10 million, terrible with the massive, 100,000 snow blowers for $10 million. And all of a sudden they said, Jim, we can only give you 90,000 snow blowers for that amount of money, or we're going to need another $100,000. If we agree, even though nothing's new coming to Home Depot, they're actually going to pay some more money, but they're getting the same exact amount of snow blowers. That's actually an enforceable contract because the law wants to give us flexibility as long as it's voluntary. As long as it's a voluntary agreement, no new consideration when it comes to the sale of goods. I keep repeating myself, but it's just such an important exception. And over half the class will get that wrong on a true and false assignment. Modification of sale contracts do not have to have new consideration on both ends. It's completely contrary to everything I just talked about. It's an important exception to remember. It's just the law is recognizing people should be flexible in business when it comes to goods, less so than service contracts, real estate contracts, or intellectual property contracts. And we'll get into Chapter 9, defective agreements. A lot of people love that chapter because it's like, is there ever a way I can get out of agreements actually because there's a problem? And it has to be defective in a certain way in order for you to have that right to get out of it, or for the other party to potentially have the right to get out of it, or both. Have a good, I was going to say weekend, but it's only Monday. We'll get there eventually. Take care.